Association, and it is great to have you with us today, man. I just so proud of the team here at AOA and just everything that we've been able to do and just responding. We had that a court case here, not our court case, but a ruling that changed what needs to be on the 3-day pay or quit and maybe some other forms as well. And so we're going to go into that and how you can respond to it. And so yeah, it's kind of like an emergency meeting here. What we were planning on covering, we'll have to cover that at another time. And so we'll book that one again. So anyway, yeah, we want to, yeah, just make sure that we have forms that are updated. I had our legal group basically look at it from San Diego all the way up to Alameda and in between, and even SNS is a part of that. So we've had a lot of attorneys take a look at at the forms and how we've updated them for that 3-day notice. And anyway, that they'll get into all of that. But I do want to just mention the live investigator search that we have in our tenant screening program. It really is unique, and it covers not just the criminal, but it also covers the civil cases that are there. So if they're litigious, it covers evictions, it covers the civil misconduct. So like the domestic violence, which is a huge deal for multifamily, and so many other things. That is a unique report. We do a skip trace to come up with a list of addresses, and then they are doing that by hand. So we have live people holding the file and going through that. And we just, because the goal is to have the most successful group of apartment owners, we just know that it's mission critical. You have to know who you're dealing with on the front end. And anyway, so that's called the live investigator search. If you're not set up with AOA tenant screening, there's an online end user agreement that you can get. Just ask for it and fill that out, and you can get access to just criminal eviction and that live investigator search. You could either do that, or you can go for the full credit reports and everything else. Full credit reports are $8.50. So we are a low cost leader on that. And anyway, so just wanted to let everybody know about that one. And really that all that is because of what California has done with that Clean Slate Act that went into effect in 2023, and just how they've redacted personal identifying information from the county court records when it's being searched, and especially when it's being searched by software. It's just not it's not giving enough information to be reportable. So what they're doing, they're using arrest data instead, which gives you, you get the personal identifying information, but it just is it's limited. It's not the full record of criminal. It's not the full list of criminal activity, I guess you could say that. And anyway, we've had some different things. We have a security deposit crash course coming up on next week. We have 10 ways to keep tenants happy, done by a property management company on the 24th. We've had the tenant screening crash course, which I did. We did a move in, move out crash course. We had a property management company talk about finding the best value for flooring, blinds, and paint. So how thick on that flooring, what type of flooring would you get? They just kind of cover that stuff. So it's not a advertisement from a hardware company. It's literally just a property management company that spent a lot of time and has a lot of, just has a lot of experience under their belt that's sharing that. Those are all things that you can find on our YouTube channel, AOA USA. And we have the AOA trade show. It's a free show. And we are doing a toy drive. And so that's all that we ask you to bring a toy to help some kids that probably aren't going to get anything at Christmas time. And there's going to be over 20 different speakers at that event. So check out our website, get registered for that. Registration is a whole lot easier if you do that in advance. There will be a lot of different things going on. I'm kind of excited to hear one on midterm rentals. Some of you are just like, I'm kind of fed up with the long-term stuff and the short-term, I'm sorry, the midterm rentals or corporate rentals. There'll be someone there that has really done an excellent job with it, an expert in that field, and he'll be sharing with you ways that you could do that. Whole lot more, tons of vendors, lots of giveaways, and so that'll be really cool. And yeah, let me see if I can find, this is kind of a cool giveaway. Here, one of these things that we'll give away, so we're gonna have these little lights and you can see that flashing. And what you do is you take the driver's license, and when you flash it on there, it'll show you a picture that normally wouldn't show. And so important to know what a real driver's license is like. But that'll save you a few bucks, that idea right there, because if you handle that driver's license and you know what you're doing, then you won't even have to run a report if you know that that's a fake. And there's just so much identity theft and fraud going on. So again, we just really want you to be able to do good reports and get what you need. If you can't catch it right there by looking at the ID, the credit report that we have has an ID verification aspect to it, and then we do the skip trace on the reports where there's a criminal search involved. Anyway, so lots of stuff. Please subscribe to the channel if you haven't, just because there are certain things that we list that they're not always a live stream. So go ahead and take a look at what we have there. Really thankful for an S&S Law Group. They've been advertising with us for a few years now. And when I look at their reviews, it's all 5 stars. So they've done a good job of keeping their clients happy, I think. And they're really focused on real estate and business law. And the real estate does include evictions. And so great companies. I want you to check them out next time you need help with something. And I believe we have Bijan Shakibkoo with us. He's the co-founder and partner at S&S Law Group. Before earning his Juris Doctorate and creating S&S Law Group with his partner, he found passion for real estate management and development. He managed over 100 million in assets for different clients. And so just super sharp. You're going to pick that up as soon as you see him. And so Bijan, I'll let you take it away.
Jeff, thank you very much. And again, I'm beyond grateful for your association. I'm sure a lot of landlords are grateful to have you on their side as well. So you guys do great work over at AOA, and it's always a pleasure holding these presentations with you. Good afternoon, everyone. My name is Bijan Shakibkoo. I believe Jeff just gave a pretty good introduction of me. I am a managing partner here at S&S Law Group. And today we will be speaking about how to get everyone out of trouble in short terms. And just before we get into that, our practice areas are unlawful detainer actions, real estate, and business litigation. Me and my partner are trial attorneys, our associates are trial attorneys. We don't sit behind any desks. We make sure that we get the work done, and we're aggressive. So today, again, we're trying to figure out how to get everyone out of messes. So we're going to talk about legal mistakes that get landlords sued all the time, and what I see all the time when clients come to me and with their cases, and how on a proactive standpoint, what we do to be able to avoid any pending litigation from tenants coming down the line. Just an agenda and overview, we'll be speaking about California and landlord-tenant laws. I'm going to dive a little bit deep into common legal practices, legal mistakes, and then also registration requirements and the new court decision that Jeff mentioned earlier that's impacting 3-day notices now moving forward. So the first thing I'd like to talk about is security deposit mistakes. These type of cases come through my office all the time, where I have a client who calls me saying that a tenant has hired an attorney and now they're disputing their security deposit amounts, whether it's the fact that they failed to provide them the itemized list of the deductions within 21 days, or they are disputing specific charges. So just on a bullet point standpoint, it's very important to be able to make sure that you're compliant under the new security deposit laws that have been implemented and the ones that have been out before. And just like I mentioned earlier, failing to provide itemized statements within 21 days of tenant vacating, that's important to do. So anytime a tenant vacates, just make sure you get in there. If there's any deductions that need to be made, make sure you implement them on an itemized statement and send it to the tenant with any deductions prior to those 21 days or within the 21 days. A lot of disputes, like I said earlier, is improper deductions or failure to itemize costs. With the two new laws that came out, one that was implemented back in April, another one that was just starting the beginning of this month, landlords are now required to take photographs of units after the tenant vacates and after any repairs or cleanings are completed. So that's very important. And behind that, the legislator, the reason why they really implemented it is kind of to clear up all these disputes that are going on between landlords and tenants as far as the repairs that need to be made in the unit and how how the unit looked before and how the unit looks after repairs. So it is important. Just make sure that you are taking photos now anytime a tenant is vacating a unit and anytime repairs are made. That goes the same for new tenancies. Now, starting July 1st, you must photograph the unit before any tenancy is commenced. So that's very important to do. Again, it's the premise behind that is just to show what the unit looked like before and what it looks like after the tenant vacates. So make sure you have those photos. And I will be speaking a little bit more on that. Dr. Balcony, another company that we partnered up with, they're actually helping out a lot of landlords with that, with their security deposits and their itemizations. Habitability and housing codes. This is a hot topic right now, and I am getting well over. I'm currently in the middle of maybe around 50 litigation cases right now for habitability issues, and it's just a lot of the claims that are being made, especially in the city of Los Angeles, especially within the county of Los Angeles, tenants do have a lot of protections, and there are a lot of tenant attorneys who are now filing suit against landlords for habitability issues. And this is why it's very important to make sure that the property is habitable and that it's in compliance with the local housing codes. So a lot of landlords, you guys have to make sure that anytime a tenant is making a repair request or is claiming any issues within the unit, do not ignore that claim. Make sure that you're addressing it and make sure that you are documenting it. So whether if it's any mold issues, any plumbing, any electrical, anything that has to do with necessities of life, any water, low water, or if there's no water in the unit, any leaks, waterproofing issues, make sure you are addressing that. This is a very hot topic, and tenant attorneys love to clench on these cases because they know the money is there. And unfortunately, as a lot of landlords are aware right now in California, it's really hard to obtain property insurance. And a lot of the major insurance companies are not even providing it anymore. So that's why it's important to make sure that you're in compliance. And I tell my clients all the time when they come to retain me, my goal is to make sure that the tenant's attorney knows that the landlord is just not going to roll over and toss this over to the insurance company, because that's what they're looking for. They're looking for the money. They're looking for the big bucks, and they know that the insurance companies are not in a position where they really like to litigate. They like to settle it, which could adversely affect the landlord, because if a settlement does come about, there's a chance that your insurance policy could get canceled or your premiums could go up. So it's important to just make sure you're on top of any habitability issues or housing code violations. Another issue that I've been seeing that's been happening a lot is unpermitted dwelling units. So I've had clients who purchase, a duplex or a new property, multifamily units, and one of the units are non-conforming. And whether if it was disclosed at the time of escrow, if it wasn't disclosed, it's a big deal, because if the unit is unpermitted, then technically the tenant cannot be even living there, and it's not going to be considered habitable. So you have to make sure that there's a certificate of occupancy for that unit where the tenant can be able to live in, because if that is not there, that is just a home run for the tenant, where they could just file suit against the landlord and recover for all the rent that they've paid plus treble damages. So just make sure that, you know, any units that you do have, make sure that there is a certificate of occupancy, and make sure that it is in compliance. Another issue that I've been seeing, and this is just ways to just, again, we're trying to avoid lawsuits. And a lot of landlords, what they do is, you know, a tenant will make multiple complaints, and after those complaints are made, landlords would act as, you know, sometimes they'll increase the rent or they'll try to evict them. That's going to be considered retaliation. And that's why it's important that if they are claiming any, you know, conditions in the unit or any habitability issues, make sure you get that situated before you want to issue any notices or any increases or anything that looks like, you know, retaliatory. So if they're complaining, just don't go ahead and just try to retaliate, and, you know, by issuing them an increased notice or anything like that. Make sure that the issue has been resolved before getting to that crossroad. Another topic we're going to talk about is eviction process errors. This is another issue that I've been seeing. It doesn't happen quite often, but, you know, a lot of landlords who are not really familiar with the local laws, they will try to conduct self-help evictions, where you know, they would lock out the tenants, they would change their locks, they would shut off their utilities, and that's illegal, and you can't be doing that in the state of California, specifically in the city of LA and LA County. So just make sure, you know, if you ever want to conduct an eviction action, make sure you go through the proper legal channels. Don't try to take matters in your own hands, because it could blow up in your face very quickly. Incorrect rent increase notices. So this is these type of issues happen all the time, where landlords will just issue notices, and the notices are either defective, or the amount for increased notice, for example, they'll issue rental increase notice when it's not abiding by either the local ordinances. For example, in the city of LA, you know, for RSO buildings, you're capped at 3%. And if you're paying for utilities and whatnot, then you could add an extra 2% to that. But it's important to make sure whenever you're implementing a rental increase to a tenant, you are abiding by either local laws, or even under AB 1482, you're under that 10% cap. And that's why it's also important to know where your property is situated and what kind of property you have, whether if it's a single family home, whether if it's a multifamily or a condominium. That way you'll be able to know how you could be able to increase, because if there's any increases done that were done illegally, then technically you're not even allowed to be collecting that amount. So just make sure that when you're implementing increases, it's done legally, and it's not done in a fashion where it's violating any local ordinances or state ordinances. Another issue is false or intimidating eviction actions. So a lot of times landlords will intimidate tenants, where they will threaten them that they're going to file an eviction action against them, or serving baseless notices. It's important that you don't misrepresent tenants or their legal rights. So a lot of the time, landlords will go to tenants saying, I'm allowed to do this, and you're violating the law. You're not allowed to do this. It's better to leave that with the attorneys, or speak with an attorney so they can advise you and properly educate you to know what you can and cannot do. Because they will use this as a defense, not only for an eviction action, but as a tenant harassment. So it's important to make sure that you're not misrepresenting the tenant, and that you're within the bounds of the law when you are speaking with them. Discrimination violation. So, I mean, this is pretty, general, where you can't reject a tenant based on their race, their gender, disability, and source of income. This is a new one that has came down, that bill was passed, where now you cannot discriminate against a tenant if they are under Section 8 housing. So if they have Section 8 vouchers, you cannot discriminate against them or reject them as a tenant. And right now, these cases are coming in that I'm representing on, where there are a lot of these nonprofit organizations that are representing tenants. And after this new bill that was just passed, they are sending test emails or text messages to landlords asking them if they accept Section 8 tenants. And if the landlord is not educated or understands how the law works and they say, no, we do not, that will be considered discrimination. And make sure, if you are renting your property on the market, and if it's on the public view, that you don't put on there that you don't accept Section 8 tenants, because you're no longer allowed to discriminate against them for source of income. So that's very important to keep that in mind. Another issue is ignoring reasonable accommodation requests. A lot of tenants, they fall under a specific class of individuals, where whether if they're disabled or elderly, they will ask for reasonable accommodation. So make sure you address it. Make sure you speak with an attorney. You can call my office. I could guide you guys through it to see what you can and cannot do. I mean, obviously, some cases, tenants would ask for unreasonable things, and that's why it's important to know what you can reject and what you cannot reject when it comes to accommodation requests. Another properties that are not compliant under ADA. This is really tailored towards multifamily, not really single family homes. Multifamily properties right now have to be ADA compliant. So if there's any entryways where if the individual is disabled, they need to enter, whether if they're on a wheelchair or not, it needs to be within the compliance, because that's another hot topic too, where you have these ADA compliant attorneys who are just shooting out frivolous lawsuits, just trying to make a quick buck, because they'll send someone who is disabled to multiple properties, and they'll try to access the property and they can't properly access it given by their disability. They'll use these attorneys, and it's a nuisance type of lawsuit. That's what I consider it. So just make sure that if you own a multifamily property, just make sure it's ADA compliant so you can avoid those lawsuits. Privacy and entry rights. So this is important to understand, where landlords, whenever they want to enter a tenant's unit, you have to make sure you're within the bounds of the law. And that's by properly noticing the tenant 24 hours in advance as to the entry. And the reason why behind that is because the tenant has a right to know why you're entering their unit. That's why it's important to see in the notice the reason of the entry. So if you fail to document the reason, the date, and the time of the entry, then that could be an issue, and they could use that against you to say that you've been entering the unit without properly giving notice. And I've been seeing these issues happen all the time. Again, tenants all the time, they do try to evade and they don't provide access. That's why you have attorneys like me who can be able to step in to address that, to make sure that the tenant does provide access to the unit, so long as it's for a legal purpose. Another thing that a lot of landlords don't know is that they cannot enter the property outside of business hours, unless if it's an emergency. So if you're trying to enter to conduct work at 6 p.m. or 9 p.m., you can't be doing that unless if it's an emergency. So just make sure that you're within the time frame of 8 a.m. to 5 p.m. to enter the unit, to make sure that they can't use these notices against you. These notices really come up when you want to commence an eviction. So for example, if you want to evict your tenant, what we do is, if it's for failure to provide entry, we make sure that we have the proper documentation that shows that we provide the proper 24-hour notice to enter. We document it by taking photos of it on the door. If the tenant refuses entry, I always tell my clients, take your phone, go to the front door, knock on the door, show on the camera that they're not providing entry. So you could always document that in the event, if you want to file an eviction action, you could use that as evidence to be able to bolster your claim. Registration requirements. So many landlords already know if your property is in the city of LA or LA County, the property needs to be registered. And it doesn't matter what kind of property it is anymore, so long as it's a rental property, you have to register it either under the Just Cause Ordinance or under the RSO. Properties that are under RSO, they must be registered annually. Same thing with properties that are under the Just Cause Ordinance, which is single family homes and condominiums now. They all have to be registered with the city to make sure that you are in compliance. So registration, you have to make sure your registration is complete. I have a lot of clients who tell me that, oh, I pay it every year. Just because you pay every year, it doesn't mean that you actually have registered it. You know, there's a forms that you got to fill out, whether you do online or not. The property needs to be actually registered where you implement the tenant's information. And you could always look on either the LA County Business and Consumer Affairs if your property is in unincorporated Los Angeles, or the LA City Housing Department. So just make sure that the property is registered, because if it's not only are you not allowed to collect rent, and not only that you can't evict the tenant, but the tenant could come back and claw back all the rent that they paid the landlord times plus trouble damages. So it's very important to make sure your property is registered, because your hands are tied. You're technically not even allowed to be accepting rent. And to just, put some landlords at ease that if the property is not registered, once you do register it, all of the rent that was paid before it's retroactive. So you will be in compliance once it is registered. So just make sure the property is registered. I've seen a lot of landlords who, more mom and pops, they don't know, especially with the new law when it comes to single family homes and condominiums now, the properties that are non-rent control in the city of LA, they also need to be registered. And that compliance date was February of 2025. I tell my clients who have these single families that own non-rent control properties in the city of LA, a lot of them, they do try to go and register and they're having trouble with it. I would tell you, don't be concerned. You will receive a bill from the Los Angeles Housing Department. And on there, it could walk you through on how to register the property with your specific ID number. This is a hot topic. Just in June, back in 2026, last month, the Court of Appeals has brought down a decision on an eviction case, and the eviction case was dismissed. It was in regards to a 3-day notice that was defective. The reason behind the dismissal was because the notice did not advise tenants on the deadline to make the payments, and the notice did not specify the date of the service of the 3-day notice. So what does this mean? This means the court, the way that they looked at it was there was a 3-day notice. I haven't seen the 3-day notice. I don't know what kind of notice that they used. But apparently on the 3-day notice, it did not specify the date that the notice was served, which entails that the tenant may have been confused onto when to comply by. And with that decision, it's putting everybody on their toes right now as to what we could do moving forward, because whenever an appellate decision comes down, the tenant attorneys love to use these as defenses, as eviction actions. And my office has been working closely with Jeff in regards to this, and we're trying to figure out ways to be able to, fix the issue with these notices. And another thing, the case that came down, the way that the appellate court made their decision, it's a little bit vague. They were not very clear as to their position as to why their notice was defective, but they stated that it is confusing to the tenant that because on the notice it doesn't state when the notice was served, the tenant would not know when is their deadline to be able to pay the rent before the notice expires. So my recommendation, and I'm sure Jeff agrees with me, moving forward, and I know this may be difficult with a lot of landlords, when you are issuing a 3-day notice to pay rent or quit, you make sure that you're including the date of the service on that notice. And that way it would clear up this issue that was brought down by the appellate court. Senate Bill 721, California balcony inspection law. I'm sure many multifamily owners are aware of this. Your property needs to be inspected for balcony inspections. And again, I've mentioned earlier that we partnered up with Dr. Balcony, where they are helping a lot of landlords with this issue, especially when it comes to making sure that the property is compliant. So all property owners are now required to conduct an inspection for all their balconies, their decks, and their stairways. And the inspection requirement must reoccur every 6 years and be completed by qualified safety inspectors, which I mentioned earlier. Dr. Balcony is doing that for a lot of landlords. The records requirements is you must maintain records for 2 inspection cycles. So make sure, and this is with everything. I tell landlords all the time, make sure that you are properly documenting everything that's going on in the property. Everything that has to be saved, save it. Any photos, any documents that are coming from tenants, any documents that you issue to tenants, whether if it's notices, make sure you save all of that and you keep proper records. Like I said earlier, Dr. Balcony, we did partner with them. They are helping a lot of landlords with the new balcony law, inspection laws, and the security deposit laws. And if you ever go on Dr. Balcony's website, if you put in the promo code SNS Law, you'll get 25% discount and 6 months off your deposit for proof for free. So give them a call. I'm sure a lot of landlords right now are either in the middle of getting compliant or need to get compliant, whether if it's for security deposit laws or for the balcony inspections. They do great work. And now I'm going to take question and answers. Everyone has any questions, I'm happy to answer them.
Great. Thank you so much for sharing and just keeping it simple and easy to understand for everybody. And we do have some questions here. Let's see, Kevin. For older apartment buildings without elevators and that have small bathrooms, technically it's not ADA compatible. What can be done there?
So for older apartment buildings, again, there are specific exceptions to that. And what I would recommend is to look up with the building and safety to make sure if your property does fall within those specific classes of properties where they have to become compliant. Again, there are a lot of historical buildings that may not need specific requirements under the ADA. And that's why it's important to just take a look at the local ordinances. Maybe building and safety can help you out with that. Again, these type of lawsuits that are coming down the pipeline, what I've been seeing is, and it could be very costly for landlords. If they have elevators or if they have steps coming up to the building, they may require a ramp to be built. Again, that's something that is more important to question the housing codes to make sure that you're in compliance with that.
All right, and Jim here, this whole webinar was sold as a 3-day notice changes, but you only glazed over it for a couple minutes. Can you expound on this a little more? So fair criticism, Jim. And yeah, if you could maybe touch on, maybe one question you could answer is, what are people supposed to do if they've already served a 3-day pay or quit, like they're in the process? And, this court ruling happens, what are they supposed to do now with notices that don't have that service date on it?
Yeah, right now we're really in the unknown, because like I said earlier, when the appellate court brings out these types of decisions, they're not very clear on what they are requesting. So for example, there's specific civil codes that state what needs to be in a 3-day notice that you have to issue to the tenant. And it specifically states what requirements it has. Now, when these appellate decisions come down the pipeline, because they're vague, the court, they hold their position on specific things. And out of the abundance of caution to make sure if you ever are in eviction action, if there ever defense is being raised, us as attorneys, we like to make sure that there is no other case law that would come in to be able to defend that. So, for example, when the appellate court decides that a notice is confusing for a tenant and a notice is considered defective if it doesn't state on there that if it doesn't state when the notice was served, because the tenant won't be able to know when to pay it. Us as attorneys, out of the abundance of caution, we just think about how can we be able to get around this. And the way that you get around it is by saying, okay, if the appellate court is saying that this is confusing for the tenant because it doesn't state on there when the notice was served, we will rectify that issue by saying, okay, you know what, we'll put on the notice now that the date of the service was this specific date. So again, this is not a statute that has came out. It's not a civil code that has came out that has a specific requirement, but this is just out of the abundance of caution to make sure that you are in compliance. We just add that on there so they can't raise it as a defense to an eviction action. Again, their decision was made in June of last month. If your notice was issued, before June 26th, the courts would take that into consideration, right? I mean, the appellate court just released it last month. If you are issuing any new notices, I would recommend that you include on those new notices the date of the service.
Right. And so with the AOA 3-day pay rent or quit notice, like we've added that date that it was served so that it makes it a little more clear for them. And that case too, when you look at it, I don't know why, but for payment too, one of the other issues was where is payment supposed to be made, and they they had it as at the tenant's residence. And so that was a kind of a mistake that they made. So that's something that doesn't even relate to anything that we all are doing. And I think also just to kind of like to what you said there, basically you're taking action for all your existing cases. You're making moves and doing things so that those cases won't be thrown out. Is that what I heard?
Yeah, again, I haven't seen the notice that was issued. Again, and no one has, and these eviction records are considered sealed records. So it's hard to get, those type of documents and see what kind of notice they even gave. So, two of their reasoning was because, again, what you mentioned, Jeff, it didn't state where the address was wrong on where they could pay the rent. They didn't say how they could pay the rent. And that's already in all of AOA's notices if you take a look at it, and within the civil code. But the main issue is the fact that the appellate court believed that the fact that on the notice it didn't state the service date, it was confusing to the tenant. So that's why we want to make sure that they can't use this against us, and it's important to include the service date on there.
And one of the attorneys that we talked to, he basically called that judge a buffoon. Would you like? It's funny in one sense. I really feel bad for the owner, but would you agree with that? That it's really just a bad decision.
It's a bad decision because it really implements a lot of ambiguity now. And now people like us who are issuing 3-day notices, we're freaking out because it's difficult to be able to, for example, when you're issuing a notice of 3-day to pay or quit, you can issue it on a Tuesday, but on your proof of service, you can say it was the date that the proof of service was created could have been the next day. So it creates a lot of ambiguity for attorneys. But at the same time, I'm not, it's California. It's just unfortunately they're not taking into consideration the ramifications that these type of decisions make, and how, again, with eviction actions, the tenant attorneys are going to have a field day on this. They're going to try to bring it in to try to dismiss all of these eviction actions.
Yeah, we've just been I've been speaking with several attorneys just because, I mean, we're all over the state. We got guys in Alameda County, down in San Diego, and just everywhere. And one thing that they said is it's really difficult for the attorneys when they are issuing the notice, because there's the date they prepare it and then there's the date that it gets served. And when you involve a process server, then they don't know necessarily if it's going to be today or tomorrow.
Yeah.
And so that really makes it complicated for you. Is that right?
Yeah, it's problematic because when we draft our notices, it'll probably go out the next day, depending on what the caseload of what the process server has.
Yeah.
So now I have to make sure that any notices that are being drafted either has to be issued the date that it states on the notice or that same day. And it's causing a lot of issues for a lot of attorneys now because the process servers are already as busy as it is. They're bouncing around the whole city and multiple different services. So we got to make sure that that notice is given that same date that states on the 3-day notice. Yeah, it is a headache.
And for the do-it-yourselfers that are serving it themselves, it's actually a little easier, because if they walk up to the door, like basically write it out right up to and then put it on the door. But the thing is, they do have to have a copy of that.
Mhm.
And they have to, and like there's other things involved there too.
Yeah, there is. And again, for whoever, any landlords that are doing it themselves, and if it's not being done by a registered process server, just make sure when you're posting on the door, just take a photo of it. You want to be able to have that timestamp documentation that there's proof. Because, when you have a process server who is, issuing notices or serving complaints, they're sworn in under the state. So, there's a presumption that their credibility is not at issue. And what tenants love to do is they love to say, I never got a notice, I never got served with anything. And that's why it's important to make sure that if you are posting any notices, take a photo of it on the door. That way you have a timestamp and you could use that if it does become an issue down the line.
All right. So yeah, we got some questions queued up here. Teresa, City of LA, is serving a notice of reaffirmation of terms to pay the rent on the 1st, would that be considered harassment?
That's a little bit
And then a
of
little more background. We can't serve the 3-day notice because their rent is below the threshold. This is really a good one, because I know there's people that serve the 3-day notice, it's below the threshold, and so is that kosher or not?
Well, again, it's really a fact-driven basis. I mean, if you're giving them a notice every single day saying, "Hey, you owe the rent. Hey, you owe the rent. Hey, you owe the rent," at that point it becomes confusing, and it can make it look like that you're harassing them.
Mhm.
Again, when you're issuing a 3-day notice, I tell my clients all the time, they're a lot of landlords, they have rent control properties that fall below the threshold, so they have to wait 2 months until they could actually move on an eviction action for
Mhm.
non-payment of rent. What
So
I
are they exposing themselves to risk if they serve a 3-day notice when it's below the threshold?
They're not
Okay.
necessarily, but if you do it once, that's fine. But if you're
Yeah, just
repeatedly
one.
doing it, then at that point, it comes an issue with the eviction action too, because when you're serving multiple notices, and then you want to use those notices on an eviction basis, you have to use the notice that was obviously the most recent, but the tenant is going to claim that I've gotten 5 or 6 notices, so which one are you referring to? So
Mhm.
that's why it's important if you are issuing notices, one time it's fine, but if you're doing multiple of them and then go to attorney and say, hey, here are the notices, I want to file eviction action, I have to decipher through that and then make sure I'm using the proper notice that was given. So again, when it comes to issuing 3-day notices, I tell my clients this all the time for properties that fall in their threshold amount. If they're paying a portion, if they're not paying the full amount that's owed, for example, I have one client where the tenant will come and just pay enough to sit under that threshold. What I would tell my client at that standpoint is reject it because you're not entitled to accept a portion. You could reject it if they don't pay the full amount. So just make sure that if you really want to get them out and you want to proceed on eviction action and they're paying a portion of the rent, you could reject it so you could hit over that threshold amount.
All right, Kevin, please specify all the details needed for the 3-day notice. And I'm going to say that's in the form. That's in whatever form you're going to use. What specific information needs to be mentioned? And Just recapping it, the date of service is really important one. And then here it says, do you have an up-to-date form? AOA does, yes, and you guys do, obviously. For Section 8 tenants, here we go, not paying their portion and it's under the threshold, should we still issue 3-day notice, which is the question I just asked, but the wrinkle here is it's Section 8. So what would you do in that case? Because when they're with Section 8, they're going to be, it's going to take forever to get to that threshold.
Yeah, it's a very sensitive topic when it comes to Section 8. What I would recommend, if you are intending on getting the tenant out for non-payment rent on Section 8, I have very unorthodox ways to get around that. Again, when Section 8 provides their payments, they're doing most probably they provide it's direct deposit into the client's account, so into the landlord's account. So that will be hard to reject that, right? And there is no really a mechanism where you can reject it with Section 8 because they're depositing into the account, and then that means you have to go ahead and write a check and then send it back to Section 8 because you haven't got the full payment of rent. Those type of cases, it's very fact driven. So I will need to speak a little in depth with the client to be able to come to some sort of a pathway that we could take. I see these issues happen all the time where the tenant just stops paying their Section 8 portion. What I would do at that standpoint is actually a lot of the times I step in and I reach out to Section 8, letting them know that they're in violation, they're not paying their portion, and requesting Section 8 to just outright terminate their Section 8 contract. And then that way we could, once Section 8 terminates the contract with the landlord, Section 8 will no longer pay their portion. And then at that standpoint, all of the rent that's owed will be their tenant's responsibility. And then you'll be able to hit over the threshold amount to be able to issue that notice to pay rent or quit.
All right, Diana, when did the registration change for single family homes in LA? I only have one and I need to ensure it's registered. Thanks.
So the law was passed in January. Well, the deadline was February for you to register the property. So it was February of 2025, where you have to register if the property is in the city of LA, and if it's a non-rent control property, then you have to register with the Los Angeles Housing Department by February of 2025. Now, again, I have clients, like I said before, that they go in and try to register online, and they're not able to do that because they don't have the specific number to be able to implement to pull up the property. At that standpoint, I would say either call the Los Angeles Housing Department. They have an office that you can walk into as well, and they'll provide you with that information and walk you through on how to register the property.
All right. Krista, how do you recommend changing 3-day notices to comply with the new ruling in, I really don't know how to pronounce it necessarily. Eshagian. I'm not sure.
Eshagian, yeah.
Eshagian.
Yeah.
Versus Cepeda. What about the part of the ruling that stated it should have the end date by which the tenant needs to comply with the notice or vacate?
Well, that's what it is. That's what it is all premised around is, the date of when they're being. So when you're issuing a 3-day notice to pay rent or quit, they'll have 3 days to either pay the rent or quit. Now, we're going back to Eshagian, the courts, for example, if you are issuing, if the date on the notice is on the 5th, and you serve them on the 6th, they're saying that it's difficult for the tenant to be able to know when that deadline is of the 3 days to be able to pay rent or quit. So to answer your question, that's why we recommend to include the date of the service on the notice so they know when that deadline is going to be.
Okay, and so here's a question, just practically. So let's say you did in your example there, you served it on the 6th. Okay, so is the 6th day one, or do you count, or is it going to be the 7th, 8th, and 9th, if that's in the
It
middle of
will be, so the date of the service does not count. It will be the following day. So it will be
the
the
following 3 business days, right?
3 business days,
So
correct.
if
So
they serve it on a weekend, the date of service is still the weekend, but the counting is not going to start until Monday. It'll be Monday, Tuesday,
correct,
Wednesday, right?
correct,
Wednesday would be the deadline.
correct. Which is why, on the notice, it must state that it excludes weekends and holidays.
Right. And that's on the AOA one and probably just about any of them that are out there. That's a change from a couple years ago that everybody's implemented. So that one should be there. If it's not, you're probably using Legal Doom, which may not have the best resource for you.
Yeah.
You like that Legal Doom instead of Legal Zoom?
Yeah. Jeff, it's crazy because whenever I have a client that comes to me and they used a AOA notice, I just think to myself, thank God, because there are some notices out there that I don't even know how they're creating it, where they're creating it, what kind of law they're putting in there. So,
Yeah.
that's why your notice, when you guys do AOA, all of your forms are compliant and
Thank you. Well, we're trying, and you can't keep up with everything. So like today, we have a message across the thing. Like we're literally getting that updated today just on the 3-day notices and for payment. But there's other 3-day notices that we still need to update.
Mhm.
And I kind of wanted to just wait till the end of the week to see if anything else changed, because like you said, there's ambiguity.
Yep.
And I mean, we already just changed we have 9 3-day pay rent or quit notices. Like
Mhm.
Berkeley, San Francisco, like there's city
Oh,
specific
yeah.
ones. West Hollywood, we did all these, but it's like it's a lot of work. And if there's one little thing, it's just the little things that matter. So we're quick to do the one that we're pretty sure on, but we wanted to just wait a little bit longer.
And that's what it is. A lot of these cases, when I'm conducting my evictions they're all on technicalities.
Yeah.
The merits of the case are there. But if you mess up on a notice and, you end up at the eve of trial and you're going to be asked to dismiss the case because you're going to lose. So that's why it's very important to have that proper foundation before filing any eviction actions.
Okay. Here's Teresa. 3-day notices have the date it was printed. Can the date of service be handwritten at the time of service? And I think you would say yes to that, right?
Yeah, so long as it's on the notice, it
Yeah.
doesn't matter whether if it's hand printed or not. Now, again, when you're for example, I have clients that they would issue one notice, and then on that notice, it may have been defective, and then they will issue another notice after that. What I would recommend clients to do at that point is on the new notice, put on there that this notice supersedes all other notices that were given. That way, the tenant can't claim that, oh, I was confused because I got, multiple notices.
Mhm. So say that again. This notice supersedes all other notices, right?
All previous
All
notices.
previous
Yeah,
notices.
yeah,
Okay.
yeah.
So, and then remember, this is on YouTube, so you can just go backward,
Yeah.
write it down.
But
And
again, yeah, yeah, yeah. I agree.
all right, Iris. Hey man, I just want to thank you so much for taking time. Do you got a little more time to answer a couple more?
Yeah,
Or this
yeah, yeah,
time, everything?
yeah.
Okay, Iris on YouTube. I submitted a no-fault eviction for a family member. That's a lot of fun. I
Mhm.
followed all the procedures, and now I'm told by the housing department that a company called Interwest. Do you
Mhm.
know anything about them?
Yeah.
Yeah.
So Interwest is a third party that facilitates the relocation payments that are issued to the tenant. So anytime that you are conducting a no-fault eviction, and you have to provide the tenant with a relocation assistance, for example, owner move-in, and after you file the application, the Los Angeles Housing Department works with Interwest, and they're a third party that just facilitates to make sure that the proper amount is given to the tenant, whether if it's either through an escrow or if you're just giving them all the money. They're just there to make sure everything's in compliance, that the tenant is receiving that relocation amount.
Mm-hmm. All right, Danielle, excuse me. Is it retaliation if tenant caused damage and went to code enforcement because I didn't pay for relocation and they caused damage. Sounds like they need to call you.
Yeah, it sounds like they do. Um, is it retaliation that on a tenant standpoint, are they retaliating that they caused the damage, then they went and to code enforcement to make a complaint? Um, Again, when it comes to a tenant making a complaint, obviously they have a right to do that with any governmental agency. Would I consider that retaliation on a tenant standpoint? Probably not. But again, that's something that I really need to, speak in depth about with with the individual.
But when does ever a housing provider win retaliation, like
Yeah,
tenants retaliate? It's like not even.
yeah. Never,
You're lucky to. We're just
never.
we're just blessed to get them out. You know what I'm
Yeah,
saying? And if they pay the rent, that's great.
yeah.
All right, Jacqueline, if I serve via post and mail, how can I complete the proof of service at the time I post? I would not have yet mailed the notice. You mentioned that inspections and repairs should be done between 8 a.m. Okay, we'll stop there with, so should they date it for when the mail's going to get there? Or yeah, that's a good question.
No, they should date it on when it's posted on the door.
So, but they're putting it in the mail.
Are they? I understood that they say post and mail, right?
Oh, via post. Yeah, you're right. Via post and mail. So it's when it's posted.
Yeah,
Is
when
that
it's posted, that's when you put the date on there.
there we go. Okay. And here's the second part. You mentioned that inspections and repairs should be done between 8 a.m. and 5 p.m. But the tenants want after hours since they work. What happened? So does she need to accommodate them? What would be your
So it depends what kind of work is being done. If they're requesting for after hours, again, it depends on how extensive the work is going to be. I mean, if they're coming in there asking for a light bulb to be changed or something to that effect, so long as you have something in writing that has the tenant's consent that they're allowing you to enter or they're requesting for you to enter on a specific time, that should be sufficient. But the rule of thumb is to get in there during business hours. So a lot of tenants, and this is not with the consent of the tenant, right? So a lot of times you want to get into a unit, whether or not the tenant wants you to or not. And if you try to get in after hours, that's when it becomes an issue. But if you're getting in within the 8 a.m. to 5 p.m. window, you're within your legal bounds to do that. So long as you issue them that notice within 24 hours, you enter within that 24 hours since the notice was posted, then you're okay to do that, which is why a lot of times tenants fail to provide access. And those are grounds that you could use in order to conduct an eviction action.
Yeah, that's right. Okay, Kevin, do all properties need to be registered in the annual rent registry?
So again, if your property is located in the city of Los Angeles, or unincorporated, but I'll start with City of Los Angeles. Any rental property in the City of Los Angeles needs to be registered annually. That is correct.
Yeah, so no, not all properties. Yes, all rental properties. So a
Correct.
lot of members got, because they have rental property, they got one, a bill to register their own private residence. So
Mhm.
that's one with the tax assessor, you can make an appeal that will be a permanent appeal. You won't have to do that every year. Do that with the tax assessor.
Yes.
All right. Does the person that writes the notice have to serve the notice?
No, does not.
Jennifer, what is the compliance for a 3-day notice if the tenant is late after the 5th day and they deposit some of the rent after the 5th day? How do we reject it? Close our account out?
So a lot of the times I have clients that have the tenant go and either Zelle the rent payments to the landlord, or they have the landlord's account information where they go into the bank and they deposit directly or through some ACH transfer. At that standpoint, I would say to either try to reject it with the bank. If that doesn't work, then you issue them a refund of the payment that was made. and something in writing that states that we will no longer accept rent and we are rejecting your notice. We're rejecting your payment. Something to document that. And again, I always advise client, any type of potential client, whoever calls me, if you are really in the intention of filing an eviction action and you want to get them out, just have your attorney do that for you, just to make sure everything is properly documented, the right language is being used whenever you are rejecting those payments.
I'll go, excuse
Yeah.
me.
No, go ahead.
Okay, yeah, so next one, Lenny is asking what's the threshold, like wondering what this is. So specifically, it's specific to LA, is that correct?
It's specific to LA, and the threshold amount is dependent on that number of bedrooms in the unit. So for example, if it's a 1 bedroom unit, they'll have to owe something around the ballpark of 1,800. I don't have the numbers in front of me, but something around the ballpark of maybe $2,000 in back owed rent in order for you to issue them a 3-day notice to pay rent or quit to commence an eviction action.
So I believe all rentals need to have the tenant protection ordinance posted in a conspicuous location.
That's
And
correct.
those prices are listed in that notice. If you don't have that notice, you can get it from the city. We have it. We also sell one that is laminated, and it's a one long page, and it takes those 2 pages and just makes it into one long page. And then
Yeah, and they just came out with a new one
yep.
on July 1st. So again, if your property is in the city of Los Angeles, there's specific notices that need to be posted on the property, which is one of them is a notice that Jeff referenced, which is the City of Los Angeles Renters Protection Notice. And on there, it pretty much advises the tenant of all of their rights and the threshold amounts and the relocation assistance amounts and what you can and cannot evict for.
Yeah, okay. And what about COVID rent? Let's say from 2022. I just got a letter yesterday. Small claim, I guess SC 500 only covers a part of the pandemic. What about the rest?
Unfortunately, the period to be able to, well, you can go through small claims for COVID rent. So again, there's always a statute of limitations that are implemented. I would say when it comes to COVID, again, it could be a very confusing topic because there were a lot of laws passed during COVID that protected tenants. So I would advise you to call my office and I could be able to look at the ledger and see, depending on what dates, the amounts that are owed, seeing if we could be able to do something about that.
All right, AW, how can I legally deny a Section 8 rental application? I'm under the impression that income, credit score, and criminal record are prohibited to use as a reason for denial. So what are legal grounds for a Section 8 applicant? So they're not saying from the get-go, you're Section 8, so no, but what are the legal grounds?
So it really, so every application that's being issued to a landlord, there are specific ways you can be able to deny an application. What I would say is this, with the way that the law reads, they're saying that you cannot discriminate based off of their source of the income. So if you feel like that whether their credit score is not good or something to that effect, that's different. What the law reads is the source of the income, and specifically with the source of the income, they're referring to any governmental subsidies that are paying for the tenant's rent. That will be considered discriminatory. So they're only looking at the fact that you cannot discriminate against a potential tenant upon what the source of the income is going to be if the third party who's paying it is a governmental agency, whether if it's coming from the
So you can, if they have eviction history, you can deny for that. If they have a criminal history that would put others in harm's way, you could deny for that. Is that right?
Correct.
Okay. And okay. Let me get one that hasn't asked before. Jennifer, so then would that allow me to give a 30-day notice, or do we need to give them a 60-day notice? I don't know which one maybe this is a follow-up question.
Mhm.
Yeah, I'm not sure which question it's from. It might be, she might be the one that's evicting a family member. It might be that one.
I would say this, if anybody has any questions, do not hesitate to call my office. We do not charge. We have free consultation for 15 minutes. So just don't be concerned. Give my office a call. We'll be happy to answer.
Yeah.
Any
Here's
questions?
the last one, and I'm only doing this one because it's really a good question. And
Mhm.
I would, if I were a betting man, I'd bet you don't have the answer.
Well, let's
Not
see.
because you're not intelligent, but
Yeah,
because of the incompetence
yeah.
of our city. So it says the updated, this is Teresa, and you deserve a prize for this question. The updated renter protection notice now states we need to attach a copy of the notice of right to counsel to any eviction notice served on the tenant. Do you have more information about this?
That's a very good question.
They don't have it done yet, do they?
I'm looking at the notice right now, actually, and I see what she's referencing. It says tenants' rights to counsel program under the qualified tenant must receive legal representation of eviction.
So we are all looking and waiting for them to come out with something, but they
Yeah,
don't.
they don't have anything on this. There's no, you see, this is this is the thing, they just come out with these rules. And if you were to go, for example, under the municipal code 151.09, it probably doesn't even state this on there.
Mhm.
So I I don't have a direct answer to that, and I'm actually gonna find that out the moment we get off, because these type of things always
Yeah, so I mean, we're checking the website every day because they don't have anything done yet, and so that's their incompetence. They create stuff like this, and then there's not even they don't have what you need to be able to do it. So you can't. I don't think you could be held accountable. If you wanted to go the extra mile, I guess you could like get a
Yeah.
summary of the right to counsel is and just put it in. That would be a cautious way to do it, right?
Yeah, what I'm seeing here, I think and again, maybe they don't have a definition for this yet, but it seems like they're singling out qualified tenants. So um, and that's what, again, my job is to always interpret things, right? And when I'm reading this, it says qualifying tenants. Um,
Hmm.
and I don't know if it's only a specific tenant that falls within that class that's considered qualified. But they should be able to come out with some clarity on, and this is the benefit to these type of things, because if this was something that was to go to court and they're going to argue the fact that the landlord didn't post this notice of the right to counsel, my job as an attorney is to go in there and prove to the judge saying, hey, this is completely ambiguous. It doesn't even clearly define specific things. It's just a generic requirement. It's nowhere within the municipal code. So I would say, as a landlord, don't really be concerned. They will be coming out with more, probably clarity on this. Again, this new notice was just created, less than almost a week ago. So
Mhm.
just give it some time, and it should be coming out. And I'll dive a little bit deeper into this. And if that individual ever wants to give me a call,
Yeah.
have them call my office, and maybe by that time I'll have some more clarity on it.
And we have one of our advisors that's checking the website every day. There's other attorneys that are also they're checking every day to see if something comes up. But man, Bijan, thank you so much, Bijan, for just taking the time.
My
Man,
pleasure.
you're busy. You're in court all the time. And so I am really, really thankful for you, and just you're so knowledgeable, and I just really appreciate you, man.
Thank you, Jeff. Same to me, and you guys, again, you guys do great work, and God bless your association, because
Thank you.
we need it. Landlords need it. So thank you very much for having me.
Oh, hey, and so everybody, before we sign off, yesterday we sent out a political action update. If you didn't get it, check your spam. If you really didn't get it, go to the AOA website, and there's a little political action square. If you click on it, it'll take you to the political action page. We have a source with one of the assembly members that's on the housing committee right now, SB 436. That assembly member believes will be potentially voted on Tuesday. That's why we sent out that that campaign. We have an email that's prepared, and it will go to your specific assembly member based on the address, the zip code that you provide there. And so it's pretty easy to do. But if you could respond to that, then hopefully they'll either kill it on Tuesday. We know that if they don't vote on it on Tuesday, it'll be kicked down the road till later in the year. But that thing, it's not dead, as some people think that it is. It's not dead. It's still going. So 436 is would change the period from the time period from 3 days to 14. And anyway, so we've written about that a little bit, but that's one that we really do want to fight. And for AOA, like we're as strong as the number of people we have that take action. So like if I walk into an assembly member's office and no one has ever written them, they're like, who's AOA? But if everybody writes and I walk in and they have like 1,000 emails, then it's totally different. So please take action so that there's weight, when we have somebody make a visit, make a call, that there's actual weight to that call. It helps us to advocate for you. So appreciate that. All right. Any last comments before we hang up here? Bijan?
No, I'm good to go. Again, thank
Cool.
you again, Jeff. Thank you for having me. Look forward for the next one that we're going to hold together.
Yeah, let's do it. And I look forward to seeing you at the trade show.
Oh, yeah. Yeah.
You'll be there. So you got to catch this guy. I mean, ask him, pepper him with questions, because you'll find out he's incredibly difficult to stump.
Yeah. Thank you, Jeff.
Okay, take care, everybody.
Bye-bye, Jeff. Thank you.